Sheena here from Atlas Agency Launch Lab and Atlas Online Solutions. Today to talk about chargebacks. Chargebacks are a nuisance. They really have become a nuisance. There is an epidemic of the people using them fraudulently, and it is really starting to impact anybody who operates online, basically. So what's a chargeback? A chargeback is when somebody, instead of going through the proper channels, just go straight to their bank or their card, like their credit card company, and ask them to dispute a charge. Okay, so for example, client goes to a mechanic, right? They request an oil change, they get their oil change, like the mechanic does everything they're supposed to do, but then the client asks their credit card company to issue a chargeback. The client signs up for organic or paid marketing, and then asks the bank to issue a chargeback after receiving services. This is what a chargeback is, okay? Now, most of the time at the moment, businesses have been losing chargeback claims because credit card companies, banks, and things like that have tended to side with their clients. That, my friend, has started to change. If you understand what is fraudulent chargeback, which almost all are, you're going to win. So what options are left for you when dealing with chargeback fraud? Even if you don't win, you can sue that person. You can sue the person who has issued chargebacks, and don't just have to do it civilly. You can prosecute them to the point that they can go to jail for fraudulently charging back on your business. So I'm going to go through a couple of examples. Let's cover what chargebacks are, what friendly fraud is, how to fight it in small claims court and the chargeback process, and then how to go after somebody for theft of services. All right, in case you haven't picked up on it yet, this is something that I am very well versed in. My experience, I guess, in a way, but what hurts me, it really hurts my heart, is that those of you who are out there in the online world and are operating online and doing your best don't know this. Nobody's taught you the fact that you have a recourse when somebody issues a chargeback, right? It comes through Stripe, PayPal, whatever it is you're using with. You got to get terrified, right? You get this panicky feeling, okay? And the onus is on you. Like, you hold the burden of proof to prove that what they've said is wrong, okay? And then it's still up to the bank as to whether or not they do. But if you know a few certain terms, all right, then one, that bank's going to side with you. And two, there's a way to flip the switch, all right? That way the burden of proof lies on them, not on you. All right. So let's talk about the different kinds of chargeback fraud. Okay. So, actually, before I do that, let's talk about why it's important to know this. Okay. Why is it so important for you to fight it? Right? If you have 1, 2, maybe 3 chargeback disputes, then your payment processor can shut you down. Okay. If you don't have the correct terms and conditions in place, contract in place, terms and conditions on your website, things like that, then they will most probably win. All right. Also, banks and credit networks check a business's chargeback ratio, okay, and then decide whether or not to work with your business based on that ratio. So you fighting it, you winning, is incredibly important. Okay. Is a chargeback illegal? Is fraudulent chargebacks illegal? Yes. A chargeback in itself is not illegal. It's there to protect us when we buy things that aren't what we're supposed to have bought, or when we buy things and they never arrive. However, fraud is. And this occurs when customers abuse a chargeback process, uses it as a refund, or engages in fraudulent behavior. If a customer is issuing a chargeback for items and services that you've provided, then chargeback fraud has occurred. If a customer has issued a chargeback for items or services that they have opted out of, then chargeback fraud has occurred. If they have received, refused, and then decided, you know what, this isn't what I wanted in the end, like they changed their mind, chargeback fraud has occurred. Now, what's more, you can still go after them both civilly and criminally, even if they don't live in the same country as you. Okay. So, can people go to jail? Right? Can a customer go to jail for disputing a charge fraudulently? Yes, they can. They can go to jail. Not only can it lead to lawsuits, but depending on the circumstances, a customer who engages in chargeback related fraud can face criminal charges and jail time. Reach out to your nearest district attorney's office and find out whether if it's yours or where your client's related, doesn't matter where. See whether or not they investigate chargeback fraud claims. Most of them do. People are sitting up and taking notice now because it is taking the world by a storm. So what's friendly fraud? Friendly fraud is not friendly at all, I promise. It's often used interchangeably with chargeback fraud, but there is a difference, okay? Sometimes you might see friendly fraud used to distinguish incidents where a customer has issued a chargeback by mistake, okay? For example, customer initiates chargeback because they didn't recognize a transition on their bank account statement. So here are a couple of examples of chargeback fraud, okay? They ordered a software online, and then they claim they never got it. Then they initiated chargeback with their bank, and in reality, they did get the software. Customer knows this, and they still initiated the chargeback. Another one is the customer tells the bank that they returned a new oven, okay, that they just purchased, and they initiate a chargeback because the business refuses to refund them for their return. In reality, the customer kept the oven, and they never even asked the business for a refund. Another one is a customer decides that they don't want the confrontation or anything of requesting a refund from a business. And so they just go to the credit card company or their bank statement and they dispute a charge instead of going through the right channels and contacting a business. If somebody hasn't contacted you for a refund, that is chargeback fraud. Okay. If a customer sees an unusual transaction on their credit card account and they initiate a card chargeback, and then in fact they realize that no, they did actually authorize that transaction, that's chargeback fraud as well, but often called friendly things. So how does the chargeback process work? All right, I'm going to share my screen. I have a fun little flow chart here to show you that I think will help explain this process. Hopefully, if you guys are visual people, then this one here is for you. So just give me a second. Oh, why is it not letting me present it? It's not letting me present it, but you guys can still see that. I'll just make it a little bigger for you all. Technology is not always my friend. It's okay. All right, so this is basically what it looks like. Okay, so the customer initiates a chargeback, and the processing or the bank or whatever your business will receive an initial chargeback notice from them. Okay, and this notice is going to include a reason code. And this is used to classify the types of chargeback that your customer has initiated. The reason code has to correspond with the reason that the customer is requesting a chargeback. For example, the chargeback code might say that this item was never delivered, like you never made me a website, okay? After the customer initiates a chargeback, you as the business owner get to decide whether or not to dispute it. If you decide to dispute it because you believe that some type of chargeback fraud has occurred, you then have to prove this, okay? If you take no action, your customer will win the chargeback by default. So how do you fight it? As part of the representment process, a business can fight chargebacks by submitting a rebuttal letter. A rebuttal letter is a letter that clearly, concisely summarizes why the customer's credit card dispute should be denied. The letter doesn't have to be long, but it should explain that the customer's claims are either wrong or fabricated. After this letter has been sent to the customer's bank, the issuing bank, their bank, will review the case and make a decision. So what do you put in this letter? Okay. You need to submit some compelling evidence. It's going to be all evidence that a business includes with its rebuttal letter is what's called compelling evidence. But it should and could include delivery confirmation, purchase order information, all records of the disputed transaction, shipping, UPS logs, FedEx logs, correspondence between you and your client, right? So let's say a client, got partway through a service and decided, I don't want to receive your services anymore. Or let's say you ask a client to provide you with access to their Facebook account so you can run a certain service for them and they never provide that, then that would be you and customer correspondence that you need to provide. A transaction receipt, the order invoice, specifying what the product is, and then what services would be provided. Checkout information like a receipt or order confirmation, address verification systems, and credit card verification value. This is for if they say, oh, I never ordered that. And then your business's website's terms and conditions and the specific sections that pertain to the chargeback dispute. Is that is not refundable? Is it the customer must supply you with information and materials within 3 business days of you requesting it or having it outlined to then receive these services? Is it that the customer may leave or stop receiving the service at any given time but are not entitled to a refund? Highlight any of these selected passages if you need to. And then you're going to be sitting there wondering, how long does all this take? How long does this take? Each bank has a different chargeback dispute rule and time frame, but typically the time frame is going to be between 20 and 45 days after the business has been notified. The entire chargeback process can take 3 months or more, right? So what happens if you've submitted all of this stuff and then you're not happy with the result? Or what if the person who asked for the chargeback isn't happy with the result because you won? You can then go to arbitration, right? It's not done. You can then go on to arbitration. And this is involving a neutral third party, like a judge, okay? And these people are going to step in, they're going to look at the evidence and make a final decision. Now, after this final decision, you can still sue them in small claims court. Do you see where I'm going, right? It comes through here. You realize, that's wrong. They should, I'm sorry, but if you haven't provided services for, you just decided not to without any compelling reason, if you actually didn't give, like if they asked for a website and you gave them a landing page, don't fight it. Just give them back their money, okay? But if it's a legitimate reason for you to dispute that charge, you can win. And here are all the different ways you can win. All right, now, here is the chart, okay? So notice that this is a general chargeback process. Right? Depending on the card network that your customer uses to handle their chargeback, this process is subject to change, okay? Now, let's say you want to sue them, right? Let's say a dispute has come across and you decide, you know what? I'm going to submit my evidence, but I'm not even going to mess with this. I'm taking them straight to court. Even if you are still disputing the charge and the bank is trying to make up their mind and everything else, you can still take this person to court, okay? Not just civil court to sue them, criminal court. So make sure you reach out and find out whether or not they investigate it for you and then take them to civil court. Now, before you take them to civil court, send them a demand letter. A demand letter outlines to your customer, your client, that you would like them to reimburse you for the chargeback. Otherwise, you intend to escalate the problem to a lawsuit. Most businesses will send a demand letter before suing because it's an affordable way to resolve the problem. So, how much can you sue them for? This depends on what state you're in inside the United States or where you are in the world. But in the United States, it's anywhere between $3,000 and $25,000. Okay? So in general, if your customer owes you more than the amount you can sue for, so let's say they owe you $5,000 and you can only sue them for $3,000, then you can only sue them for $3,000 and then waive the additional amount. Okay? So how much does it take to take a customer to small claims court? In the United States, it's between $15 and $75. That's not very much at all, is it? That's how much it costs for you to turn the tables and put the burden of proof on them. You will also need to pay to notify your customer that you're suing them. Okay, this is called serving, and it's got a range between $0 and $125. The rules around serving are really, really specific for each state in the United States, so make sure that you review those rules before you do it. So what is a small claims hearing? Okay, it might feel overwhelming to take your customer, your client to court. These are meant to be quick and informal. And here's what you can expect when you sue a customer in a small claims court. Right before the hearing, the judge is going to ask you and your client to show each other the evidence that you've brought to the hearing. Consider using some of the same documents that you used in the chargeback process. Okay. The judge will then ask why you are suing your customer in small claims court. This is when you tell the judge that your client issued a chargeback when they shouldn't have. The judge will then turn to your customer and ask them to tell their side of the story. Now, this hearing will last around 15 minutes, okay? That's going to depend on many different factors, but on average. And very rarely will a judge tell you at the time their decision, okay? You will probably get told, you and your customer will probably get told that a decision will be mailed to you, and this will take a few weeks. So how do you prepare for a small claims hearing? Research the law. If you don't have a team, a service, or somebody else that handles this for you, then research the law. If you're unsure about any of the claims that you want to make in court, consult an attorney. And then prepare what you're going to say. During the hearing, the judge is going to ask you and your client questions. So be prepared to discuss the chargeback dispute, how much money your customer owes you, and why you think that your customer owes you that much money. Okay? Then prepare your evidence. You're going to want to have your evidence organized with titles, dates, why that piece of evidence is important. Include the compelling evidence that you've used in the chargeback process. For example, a delivery information or tracking information, a transaction receipt, an order invoice specifying which product you sold, and things like that. So that is how to basically turn the tables. Now, what if it isn't a chargeback? What if it's a situation where you've provided a service and then a customer's just refused to pay? This is theft of services. Now, a chargeback is also theft of services, okay? But this is a criminal offense in every single case. This is where someone intentionally obtains the benefits of services without paying for them or providing compensation. This can include a wide range of services like labor, design, professional services. For example, you built them a website and you were hired by this person to teach their sales team how to upsell, things like that. And then after completing this, you expect the business owner to pay you $6,000. However, they never pay you for the services that you've performed. Individuals that have committed theft of services can find themselves liable not only under criminal law, but under civil law as well. Okay? In this example, you can then sue this business owner for $6,000 in small claims court for services that they've performed. Now, why use a demand letter? So remember we talked about demand letter before? We have to use a demand letter here as well. A demand letter should be and can be sent in situations where a client hasn't paid you for your services. And in the demand letter, you can ask for payment. You can notify the individual of your intent to sue if you don't get paid for your services. And here are 5 reasons that you should first send a theft of services demand letter before you take legal action. So depend on the state that you're filing on, you might be required to demand payment before filing. For example, in California small claims court, you're required to first demand payment from the person you're suing before filing. By sending a demand letter, you're completing this requirement. Then depending on your state's laws, you might be required to send written notice before suing someone. For example, under Florida law. And this is going to enable you to recover additional damages for theft of services. Often referred to as civil theft. And you must first provide written notice by your intention to sue and then give them 30 days to respond. By sending a demand letter, you are fulfilling this requirement. A demand letter signals to the person who's committed the theft that you are serious about resolving this dispute and you are willing to take action. Sending a demand letter, that's number 4, for theft of services ensures that there is a record of your attempt to settle. So while demands can be made orally, we recommend that you make any demands in writing. Writing a letter can sometimes be a really, really effective way, and it's more formal. Okay. Now, number 5, the most important reason is that it may lead to a settlement without incurring any court costs. All right. Do you need to hire an attorney to write this theft of services letter? You do not. There is no formal requirement in the United States that you need to hire an attorney to write your demand letter. You can hire an attorney if you want to, but you can also write it on your own. So what do you include in your demand letter? I have an example here that is going to show you what you can put inside of your demand letter. Okay. So the important things is facts and explain why you're seeking payment. For example, you work as a mechanic, okay, and you repaired a damaged car, and then after performing the repairs, your customer didn't pay you, right? In the demand letter, discuss how much it costs to repair the damage, what estimate you provided to the customer before performing the repairs, and things like that. Include your contact information. So the client or the person that you're suing knows where they can reach you in case they want to reach a settlement. Okay, most people choose to communicate via email or other forms of writing, so make sure that you include an email address along with any other form of communication that you're comfortable with. Include where you'd like to receive payment. If you own a business, your client might email the check to you, or you could consider using Venmo or PayPal or even a payment link if you're comfortable with those options. And then attach other documents or photographs that might be necessary and could be used as evidence later in a legal action. Okay, for example, photos of the work that you performed, a contract, invoices, even a police report if you have reported the theft to the local law enforcement, and then include a deadline. Typically, you can give 14 days to respond and state that if they do not respond within that time, you intend to sue them. However, some states have different codified theft of services, and you should confirm that there's not a different timeline that you're required to give that person. So here's a sample letter. So when you start, put your name at the top, your address, your date, the other party's name, the other party's address, and then how it was delivered, like via USPS or whatever. Okay. Demand for payment of services. Dear other party's name, I am contacting you, demanding payment for amount owed. I am attempting to resolve this out of court, but if we cannot come to an agreement, I intend to sue. Here is a statement of my case that I intend to submit to the court. On this date, I was hired by this person to perform this service, and I was going to be paid this amount of money, okay? And then on this date of service that I performed it, I initiated the service as promised, and for result, this is what happened, okay? After completing all of my work, I then invoiced this person for this amount to be paid by this time. However, I've never heard back from the other person and have yet to receive payment for the work that I performed. I am now demanding payment for this amount. I look forward to resolving this matter amicably, and I'm amenable to discussing mediation. You may contact me at this email address if you would like to discuss this matter further. Please send me a check payable to my name to the address listed above. If I do not hear from you by 14 days from now, you leave me no alternative but to file a lawsuit against you. In the event of a lawsuit, I intend to seek redress to the fullest extent permitted by law, including, but not limited to, additional damages, legal service costs, court costs, and accrued interest. All right. Now, once you've written all of that, you can sign it. All right. Sincerely, your name signed. Okay. This is how you write a demand letter. And you can write this demand letter for a chargeback. You can write this demand letter for an unpaid invoice. You can write this demand letter for any other time that people have actively taken money from your business fraudulently. Okay. So the most common way that people send a demand letter is via email or mail. For letters that you mail, consider sending your letter with tracking information so that you know when it's being delivered. And then the next steps, what are the next steps once you have, I'm just going to remove this from the screen. Once you've sent your demand letter, what do you do next, right? So if you receive no response, consider sending a final demand letter. Okay, if after sending a final demand letter you still haven't been paid, consider suing for theft of services in small court. Small claims courts were designed to provide accessible and cost-effective way for individuals and businesses to resolve their disputes without the need for a lawyer. In most cases, the parties involved will represent themselves in court. And if you have a dispute against somebody for theft of services, suing them in small claims court could lead to payment. So that, my friend, is basically how you flip the script. And instead of you having the burden of proof, they now have the burden of proof. This is how, instead of just, I disputed it through Stripe or whatever, and I didn't win, and it's not the cost of doing business. You still have options. Now, for more information on exactly what counts as a fraudulent case, what counts as a fraudulent chargeback, how to identify them and things like that, have a look at the downloadable in the comments, and I'll see you guys next week.